But we begin tonight with the wild card in the mishandling of classified documents case against the twice impeached, twice indicted former president, Donald Trump. The wild card is the judge who is set to oversee the case, U.S. District Judge Aileen Cannon. You may remember her as the Trump-appointed judge whose past decisions on this very case were overturned not once, but twice by the conservative 11th Circuit Court of Appeals in scathing opinions. She may provide Trump his best hope of yet again receiving more favorable rulings, like perhaps quashing key evidence like the damning contemporaneous notes provided by Trump's own lawyer, Evan Corcoran, or maybe even delaying the trial until after the 2024 election, or issuing a directed verdict of not guilty. I mean, it's not like she can rely on her vast criminal trial experience to help her through what will be one of the most significant criminal trials our country has ever seen. And that is because, as the New York Times reports, she barely has any such experience. As the Times points out, of the 224 criminal cases that have been assigned to her, only 4 actually went to trial. And those cases involved basic charges, including accusations of gun possession by a felon, assaulting a prosecutor, smuggling undocumented migrants, and tax fraud. Nothing like the Espionage Act or obstruction of justice. In all, those 4 cases added up to just 14 trial days. I should add that before Trump gave her this lifetime appointment to the bench in 2020, she had not previously served as any kind of judge. And while special counsel Jack Smith will have to wait and see how Judge Cannon handles this case, she might not be the only judge to oversee a case regarding those classified documents. One of the most striking revelations in the 49-page indictment were the 2 occasions when Trump showed classified documents to others who did not have the proper security clearances. While Trump was charged with illegal retention of classified documents, there was no charge for dissemination. That's likely because it happened at Trump's Bedminster Golf Club in New Jersey and not in Florida, where these charges were brought. As Andrew Weissman points out in The Atlantic, Smith could bring that charge, which also falls under the Espionage Act, in New Jersey. Weissman writes, the Miami indictment conspicuously excludes many facts surrounding Trump's actions in Bedminster. What boxes were taken there, what they contained, how they were kept at the golf club. This silence suggests that there might be more to come from the famously hard-charging Smith and his team of prosecutors who put together an otherwise highly detailed 49-page indictment. And as it relates to the special counsel's attempts to hold Trump accountable for his actions, Smith is still moving forward on his other investigation into Trump's role in the January 6th attack on the U.S. Capitol, with a grand jury in D.C. continuing to hear testimony from witnesses as recently as yesterday. Regarding that investigation, Weissman this morning predicted people who think Jack Smith may not bring a J6 indictment, in my humble opinion, are going to be proved wrong. No way that he's going to give Trump a pass on this. Joining me now is National Security Attorney Bradley Moss and Timothy Hafey, former lead investigator for the January 6th Select Committee. Thank you both for being here. Let me back into the Aileen Cannon piece and start with you, Tim, on the J6 thing. When you saw that the charges were brought in Florida, was it your assumption that this is the sum total of what Jack Smith was going to do, or would you be surprised if nothing more was done, or if something more was done in D.C.?
I think, as Andrew's piece in The Atlantic points out, it's technically possible that Jack Smith could bring a subsequent case on dissemination in New Jersey. I'd be very surprised if that happens. Right. When I read the detail in that indictment, which includes the evidence of dissemination, which in part is evidence that proves retention, I think that's it. I think for the documents case, for the Mar-a-Lago matter, it's one case. It's brought in Florida. It's brought in Florida because that's where the core conduct happened. I also think it potentially provides more legitimacy to the case. If there are convictions in this case, as the special counsel clearly believes the evidence is sufficient to sustain, then perhaps it has more credibility in the eyes of the public if it's brought in a jurisdiction, even in front of a judge, favorable to the former president, as opposed to D.C., where there'd be this narrative that that was a sort of a stacked deck against it.
And as far as New Jersey is concerned, would it surprise you if they had that as a back pocket, just in case Aileen Cannon decides to go rogue? Then they could drop charges. They could just drop charges on him in New Jersey.
Yeah, it's possible, but I think unlikely. I think prosecutors want to bring as many facts as they can in one indictment. And he wants to bring all the evidence of the dissemination in a single case. It's really not in the prosecutor's interest to have some facts admissible in case A, other facts admissible in case B. Now, exactly as you said, Joy, if the judge is wrong, goes rogue, does some things that are clearly improper, then they have a backup option and could bring a subsequent case. I don't think anybody wants that. I think the Department of Justice has brought their strongest case in this indictment. It's going to be in Florida. They believe they can win the case. All that evidence that could have been brought in New Jersey, it's going to come into a courtroom in Miami.
Let's talk about Judge Aileen Cannon, Bradley Moss, because let me just read a little bit about her. This is what the New York Times wrote about her. Her Senate Judiciary Committee questionnaire asked for every published writing that she had produced. She listed 20 items. Of those, 17 were pieces she had written in the summer of 2002 as a college intern at the Miami Herald's Spanish-language sister publication, El Nuevo Herald, with headlines like "Winners in the Library Quest Competition." The other 3 were articles published on Gibson Dunn's website describing cases the firm had handled, each of which had 3 other co-authors. She doesn't have a lot of experience, but I think the key piece of experience she lacks is anything that has to deal with national security. And the challenge here is that she missed when she was dealing with the special master issue and got smacked down by an appeals court. But in this case, are you concerned about her skill level when it comes to handling a case where there is so much classified material, it probably can't even be shown to the jury?
So I'm not yet worried about her skill level so much as I'm worried simply she doesn't have the background information and knowledge and understanding of these types of procedures. And to be fair to her, outside of D.C. and the Eastern District of Virginia, where most national security cases are brought, most judges don't have that expertise or knowledge. There might be a select few in areas where it's been needed for an occasional mishandling case that was brought, but generally all the cases are handled out in D.C. or Virginia, so most judges wouldn't have that expertise. She can certainly be educated on it. The prosecutors know they're going to have to bring up to speed whoever the judge was on the details of the Classified Information Procedures Act and how these national security cases transpire. But ultimately, this was the risk that you take when you bring a case in South Florida, knowing that's where venue was most appropriate, but also knowing that the judges there aren't going to have the same exposure on a regular basis to national security cases. And they just had a bad luck when it came to the draw on the random assignment, and they got Judge Cannon.
Well, I mean, the other question I think I have is whether or not she might be swayed by the idea, because she does, in her previous rulings at least, we don't know what she's going to do, she gave such great deference to Donald Trump. And whether she might be persuaded by his arguments that these sorts of national security materials could be possessed by Donald Trump and that she wouldn't really have the experience with these kinds of cases to be able to make that kind of judgment.
So I'm certainly concerned, given what she did last fall with the rulings, how she might view some of these more frivolous arguments, as far as I'm concerned, from Mr. Trump. But the one, safety valve here is in these rulings would come in pretrial motions. If it goes the wrong way, the prosecutors have the ability to immediately appeal to the 11th Circuit, and Judge Cannon no doubt knows that. I can't believe she would have liked having been so publicly rebuked twice in a couple of months by the 11th Circuit. So that's going to play in, to her mindset when she evaluates how to rule on these cases, and no doubt will play a role here. I know a lot of people are really concerned because it's Judge Cannon. That might ultimately be a problem. That might work in Mr. Trump's favor. I'm not there yet.
Okay, well, that's actually kind of uplifting for you to say that. Tim, let's talk about Donald Trump's. The thing that was so striking about the Washington Post article is his almost desperation to hang on to these materials. He obviously thought it was cool to have them, to have these national security secrets, and he was just not going to give them back, no matter what, and thought he was entitled to keep them for whatever reason. The person he was listening to, instead of his lawyer, Christopher Kise, who was saying, no, you got to give it back, is a guy named Tom Fitton, who is not a lawyer, even though the organization he runs is called Judicial Watch. He took advice from him and a range of others who told him he could legally keep the documents and should fight the Justice Department, according to advisors to Trump. Trump would often cite Fitton to others, and Fitton told some of Trump's lawyers that he could keep them, even as they disagreed. My question is whether or not Trump will try to compel his current lawyers, Mr. Keyes, who obviously knows better, to try to make that argument again in court?
Yeah, there's a pattern here, Joy, of the president forum shopping, looking for advice from people who tell him what he wants to hear. The same thing happened with respect to the election.
Right.
He had very capable lawyers like Bill Barr, like Pat Cipollone, like his own campaign general counsel telling him, sir, you lost the election. There's no evidence of voter fraud. He had other people in his ear telling him otherwise without a basis in fact. So he may be listening to Tom Fitton, who is not even a lawyer, certainly not an expert in the Presidential Records Act, when any other sober, capable lawyer who is steeped in those facts is telling him otherwise. That's not a legal defense.
Right.
You can't rely on unreasonable advice.
Let me ask you this question about the January 6th piece of this. We just had, well, let me just ask you the January 6th piece. Would you expect a January 6th case to also be brought at the same time? And could they be brought at the same time, in theory?
Yes. Look, the Select Committee, even just based on the evidentiary record that we developed, recommended criminal charges. We found evidence of intent to obstruct an official proceeding, a conspiracy to prevent the transfer of power. Jack Smith's gone beyond that. He's gotten the testimony of Mike Pence and Mark Meadows and overcome privilege assertions by Pat Cipollone and others who had asserted privilege before the committee. I think the case is only getting increasingly strong, that the president intended specifically to prevent the certification of the election, and that makes an indictment likely. Now, when and what venue? I think it's likely D.C. I think it's likely later this summer, this fall at the latest. They want to do it early enough before the primaries. That's DOJ policy. But I think it's coming.